Okay. That way, if there's questions, I'll decide. I'm going to record this, and I have your permission to do that. And then I'll decide at the end if I'm going to post it to the course, depending on how it goes.
Okay.
Okay. So I did receive your documents. I didn't get a chance to look at too many of them. Um, but why don't we start with the easiest? So we'll go to the healthcare power of attorney.
Okay.
So I brought it up on the screen. You should be seeing it. Notice to the individual signing. You see that?
Yep.
Okay. So this is a pretty simple form, and most of this is the first 4 or 5 pages is all statutory. So I'm just scrolling through yours now, and you're doing everything you've done there is correct because you're simply copying it over. So now we get to this page, which becomes specific to Kirk. And let's see, so you have James T, and you have his address, that's fine. I'm assuming these addresses are on your list of assumptions, this Saugan Avenue, okay? So that's good. You have William. Going down through this, one mistake you're making here is I'm putting the cursor, the X that you have in there,
Okay.
that should be left blank because
Okay.
those boxes are checked when we do the will execution with the client, in the real world when he's sitting and signing all his documents. So
Okay.
you don't want to put that X in there.
Okay.
Let's see here. Same deal. See, this one is optional. And then you have this
Gotcha.
X here, so we're going to remove that X. Going on further, the James T. Kirk is good and today's date, so your list of assumptions would show that that's the day he's signing, that March 1, 2016. Again, this X would be taken out of here as well.
Okay.
Then just kind of a formatting issue. You want to take this, I saw and move it over so it lines up. That's just me being nitpicky,
Okay.
but you want this to be camera ready for the client.
Gotcha.
Witness name is fine. You did that right. That's good. Again, Kevin looks good. So yeah, I mean, this form you've done well. Just those X's, just so you realize, we're just doing that. We leave those blank and the client makes their choices at the signing conference.
Okay.
So I would say overall that one looks pretty good. I'm going to go to the property power of attorney now.
Okay.
So you should be seeing on your screen short form power of attorney for property.
Yes.
Okay. So again, this is statutory, so you've left this. That's correct to leave this all here. Let's see here. Again, the JPK,
Yep. Blank.
yeah, you're going to leave that blank so that he can initial at the signing conference.
Okay.
So now we pick it up where the form is particular to him. So he is the principal and William's his first agent, so that's good. All this note material, and I'm saying this more because I'm recording this and I may put it up to the class. All this note material that's bold and parenthetical, we do leave that in the form because it's part of the statute. This is a statutory form, so you've done that correctly. You've left all these powers, and we want to leave those powers because we want to give William as much power as possible since he's our client's son. Let's see here. Here, this restriction you've put in here, that probably does not need to be there. We can just leave that. Let's see, I have to look at this. I think you just want to leave that. I think you want to take that out because what's going to happen in the real world or in the assignment, we'll talk about it. But these shares of common stock and other assets are going to have to be retitled into the name of his trust. And then the trustee would have the power to deal with the stock through the trust. So I think you want to take that out.
Okay.
I see you picked up my language here, which is exactly right. So again, I'm saying this more for the benefit if we decide to post this up to the course. We put this language in here simply because we want to give the agent as much power as possible. And the reason we do this authorization to amend or revoke is 2 reasons. A, Kirk trusts his son William, and in the real world, most parents who are naming their child as the power of attorney agent, they trust him. And the reason we want to give this amend or revoke is because if there was some kind of tax code change or something like that, and James is incapacitated, then William would have the power to deal with the trust. So that's why that's there.
Okay.
Again, I'm saying that more for the benefit of anybody else listening to this than for you, but you have that right. Coming down, yeah, this comes up all the time. I'm in paragraph 6. What we want to do here is because William is James' son, we want to leave this blank.
Okay.
And 7 you would leave blank as well. The reason we leave 6 blank is because then it makes the power of attorney effective the day it's signed. So
Okay.
the problem with, again, I'm saying this more for the benefit of the class than for you in particular. The reason we don't want to put this determination by a physician that I'm incapacitated is, A, that's getting harder and harder to get physicians to do those letters of incapacity. And since we're using a family member as the power of attorney holder, we simply want this effective the day it's signed. The only time we'd ever put this kind of restriction is if we were using some kind of power of attorney holder that wasn't, so close to our client. Number 7, a power of attorney is based on principal agent law, so when he dies, it dies automatically. So again, we take this upon my death out.
Okay.
All right, let's see here. And just stop me if you have questions as I go. Again, I'm saying this more for your benefit and the class. Here with 8, since William was named, I'm going to scroll back. So you've correctly on page 1, or I don't know what page it is, but on the first page that relates to Kirk, which would be page 3, you've correctly, James is our principal, and you've correctly named agent number 1 as William, and that's following the assignment. So then if we go to paragraph 8, it would be redundant to have William in here. So we want to take William out. And so it should only, yeah, you got it. So it should only say Kevin.
Okay.
Again, striking 9, I think you just want to leave that.
Okay.
Simply because there's no reason to strike that.
Okay.
And for the benefit of you and the class, I'm reading this. I'm seeing your documents for the first time. I didn't have time to review these this morning. So nothing I say here is a criticism to you. I'm just kind of helping you out.
No problem.
See here. I mean, overall, you've done pretty well here. So you got the date right in James. That's good. Undersigned witness, and you picked up James. So that's proper. You might want to consider, this is Professor Dean being nitpicky. You might want to consider, let me scroll down here for a little bit. Yeah, so now this isn't me being nitpicky. This is how we do it in the real world. So this is where the witness signs and the witness certifies Kirk is known to be the same person. So see where I'm putting the cursor right now? I'm moving around a little bit.
Okay.
So you would want your witness's name to be printed there, but leave this blank so that the witness can sign at the signing conference. And then if we go down farther, the second witness, not applicable is fine. We don't need that in Illinois. But the reason this becomes important is now when the notary comes in, certifies that James, you got that right, but see this blank here and the witness?
Okay.
So if you used the witness you used, my recollection was Diane Nichols or something like that.
Yep.
So if it was Diane Nichols that you typed the name underneath her signature, then you would also put her name right here.
Okay.
You see how that works?
Yep.
All right. Let's see. Dated's fine. Take this space out if you can get rid of it. Looks like there's a tab space there.
Okay.
That's, again, just being nitpicky. You have this right. So even though James signs the document and it's effective the day it's signed, these are specimen signatures. So we can always get William's signature and Kevin's signature at a later date. And the reason for that is when William signs here and James certifies his signature, if William was then to go into a bank and say, I have my father's power of attorney, I want to deal with one of his accounts, the bank is naturally going to ask for an ID, and then they would compare that signature right there that James has certified to William's present day signature. So that's why we
Okay.
do that. So you have that right. You have the preparer right, that's good. And then all of this is statutory. So you have a little bit, but let me go back. I think you've added this, haven't you? This James
No.
by William.
Oh, I might have.
Yeah, I think that comes out. Go back and look at the statute, but we don't add, there's nothing particular to the client here, so I think this comes out.
Okay, gotcha.
Or go back to the form I provided. I'm doing all this off the top of my head. Okay,
Okay.
so that takes care of the 2 power of attorney forms.
Okay.
Let me go to the will. So does your screen show last will?
Yep.
Okay, good. So here you have Kirk, and that's fine. You might want to consider adding a zip, but that's just, again, nitpicky.
Okay.
One mistake you're making here is he's a widow, of course, and he's a parent, but he's still the parent of Jordan.
Okay.
So even though we're disinheriting Jordan, he's still his parent. So we want to add Jordan in here.
Okay.
Okay. Again, this is my first time looking at your will, so I have to kind of read it quick here. Yeah, your Article 2, Paragraph A is fine. I like how you did this. I like how you give. Sometimes we see lawyers, especially, I don't want to say old-time lawyers, but lawyers who've been lawyers for a long time. They'll say, I give, devise, and bequeath. Well, that's just extra verbiage. In estate planning, we want to be specific and as succinct as possible. So when somebody says, I give, devise, and bequeath, it says the same thing as I give. So again, I'm doing this more for the benefit of the class than for you. So I like how you put, I give the following personal effects as follows. Various tools. I don't have the facts of the assignment in front of me, but I don't believe, you'll have to look at the assignment. I don't think the Suburban was going to 2 people. Check that, okay?
Okay, so he owns.
Yeah. You have to work on your.
Well, he says the remainder of his personal effects to be divided equally between William and Kevin.
Okay, so
But
he
doesn't say, he just says that it's owned by James T. Kirk.
Okay, so he specifically, so you have the assignment in front of you?
Yeah.
Okay, good. I can pull it up if I need to, but he specifically wants the hand tools to go to William and the Rolex to go to Peter. And then does he want the remainder of his personal effects divided between William and Kevin?
And the remainder of his personal effects to be divided equally between William and Kevin. Yeah.
Okay, so what you want to do here is you want to take this Suburban out of here. You don't need, because he might not, he could live another 15 years. So
Okay.
So what you've done in your B subparagraph 1 is good. You know, the tools to to William Kirk, the classic gold Rolex, these are called specific bequests. So
Okay.
you want to work like, you want to always do your specific bequests first. So hand tools to William's fine, move Rolex up to here, up to underneath, then say the remainder to be split between Kevin, and go back and look at the will that I provided to the class because I think I have some language that goes to that.
Okay.
Be cautious here because your executor shall sell any property as to which my children. Well, if he was leaving it to all 4 children equally, that'd be one thing, but he's not doing that. So your any remainder property is the idea here is if William and Kevin are arguing over something, the reason we do this, I call this my anti-bickering clause, because it says to William and Kevin, listen, you guys got to work this out, and if you can't agree to an item, then we'll simply sell it, and we can always divide cash, and that stops the bickering in the estate administration. So go back and watch that, but I know you've picked up this child because that's in the form that I've provided, but you need to make that specific. Again, I'm saying this more for the benefit of the class than you in particular. because I suspect your classmates will have done the same thing. You want to make this specific to William and Kevin.
Okay.
Interpreting the world, that's fine. That's good that you've got the disinheritance. Again, I'm only reading this for the first time from you, so bear with me. That's fine. You have that right.
Okay.
Again, this is just, we want this real world ready, so when you turn it into me, I'm assuming the documents are going to be as good as if we presented them to the client, so you wouldn't want this big space here.
Okay.
You want it to have a natural flow. Residue, that's fine. So Article 3 is good. I haven't been really watching your articles, but I'm sure that article numbers are flowing. Go back and look at the will I provided, the payment of all your debt. I can't remember if the will I provided, if this clause, it doesn't really matter, but you want the will to have a flow to it. And I can't remember if my Article 3 was residue and Article 4 was debts or vice versa. I don't know if debts come before residue. I think in the form I gave you, they did. Now, when we get into your Articles 5, 6, 7, this is what we call boilerplate. So you're picking this up. You've done it correctly. It looks good. It looks like you have it formatted correctly. Let's see here. Your Article 8's fine. Somehow you have
Okay,
this.
so I highlighted that because I did not know, do we leave that in because there's no co-executor?
That's a very good catch on your part. That shows me that you're working on this. The answer is you could, but you don't need to. So because we have a pecking order, right? We go William first and Kevin second.
Yep.
I seem to recall that from the facts. And the reason I don't have the facts in front of me is I rushed to make sure I was in time to meet with you. So I left them at my office. So I'm doing this off my memory. So let's see here. Yeah. So for purposes of interpreting the words, you'll have to go back and do a word search. If this word co-executor is not being used anywhere in the will, then this sentence could come out. But the word co-executor may be in one of the boilerplate provisions.
Okay.
Leaving this in here does not affect the legality of the will. The will is still legal either way. So maybe err on the side of caution, but you'll have to check that. Guardian of the person. So that's right, because the guardian of the person you need to follow, when I say you, I mean the class. You need to follow the power of attorney. Guardian of the person is power of attorney for health care. Guardian of the estate is power of attorney for property. And we always do that in the real world. So in this case, the guardian of his person in the facts is William first and Kevin second. That seems to be my recollection. So then you have this right. So when you do this in the real world, in the will, the guardian of the person always has to follow the healthcare power of attorney. And I'm assuming you got this one right too. Yeah. And then the guardian and again, I'm saying this more for the benefit of the class. The guardian of the estate always has to follow exactly the order of the power of attorney for property. So you have that. That's good. We always want to waive bond because we don't want family members to have to post bond. It's expensive. The one thing that you're missing in here, and then I'll come back to your witnesses, is he has a minor child. And I dealt with one of your classmates over the telephone, and she found language to appoint the guardian of Robert. So that needs to be added to this will. And what I need to do, I'll try to do that after this meeting, is I need to put up some language to that. I thought I did. So I will do that. I'll give you some form language as to the guardianship of Robert, but that needs to be in here.
Okay.
I think he said, is the guardianship of Robert like Betty Morgan or something? I can't remember who I said.
Yeah, it goes to his sister, Sally's sister. For him to be Sally's sister, Betty Morgan.
And then if she cannot
serve, if Betty can't, then it'll go to Jane. Wants William to be.
Okay. So there you need to have language in the will, because what that shows, the reason we do that is that shows what Kirk's intention is as to who would be the guardian of his minor child, Robert, should he pass? Not he.
Okay.
Should James pass? So the will then operates as evidence of James' intention. If there was ever a guardianship hearing, we could show the judge the will and say that our client James wanted Betty to be first, and if she couldn't serve, then whoever I put second. Did I put William second?
Yep.
Yeah. So that's why that's in there. And again, I'm saying that for the benefit of the class more than just you. But yeah, that's a miss in your will. You definitely have to have that in there.
Gotcha. Okay.
Let's see here. The signature for Kirk looks good. Diane Nichols and Franz, just put their name under the line, and then they would sign where you have these names.
Okay, gotcha.
So just again, and then you have some bold here that, from a grading point of view, I probably wouldn't take off a point for this, but we want it to look as good as possible for the client. So these little underline bolds, that's just cleanup. That is truly me being nitpicky though.
No problem.
All right, so let's go to the trust. And again, for the benefit of the class, I have not seen this trust until now, so I have to take a little bit of time to look at it. Let's see. And you have some stuff highlighted. Okay, that's good. Here, this is a mistake. So, and it's because I provide, just like the real world, the lawyer would provide you forms, which I have done. And then you have to massage those forms into the particulars for this client in the real world, or for the particulars of this assignment for the class. So here, I believe that we have, instead of his children becoming, let me see here. Yeah, see, Bank of America is going to become his corporate trustee.
Okay.
And then one of your classmates asked a very good question via the forum activity area earlier today or yesterday, that since we're naming Bank of, and again, I'm saying this for the benefit of the class more than you in particular, since we're using a corporate trustee, we don't have to name a successor corporate trustee. So all you really have to do is say Bank of America or its corporate successors or assigns, and that's how we handle that. So you have to go back because William and Kevin are not going to be trustees.
Okay.
So yeah, I'm glad you highlighted this, but you're going to have to go back and work on this a little bit.
Yeah, I wasn't sure, and that's why I was like, this doesn't seem right.
Yeah.
Okay.
Yeah, no, that's a very good catch on your part, and I'm sure your classmates who listen to this will be glad you did that, because I have a feeling that's going to happen quite a bit. Let's see, third. So now we get, third is fine. And if you think about it, under the facts, and this is real world now, under the facts, the real estate plan for Kirk, other than his healthcare decisions, is in the trust. And that's why when I'm grading this, I focus, specifically on the trust, because we have to make sure that Kirk's dispositive intentions are satisfied. I like how you did this with the 123 Smith Drive. And I know you picked that up from the facts and from the forms I provided. Let me just read this. In the facts, I think he just wants the house to go to Kevin, right?
Yep.
Okay, so I don't think you need the rest of this. If Kevin was not to survive, we can simply let the title of the house lapse into the trust as part of the residue of the trust.
Okay, so then take that all out?
Yep, take that all out. I'm reading, if in the event Kevin Kirk does not survive me, I direct any ownership, subjects shall be distributed, and rather than per stirpes to the descendants, because the way you have this now would be to the descendants. I mean, this would bring a lot of people into title on that house. So you could simply have it, yeah. So you could simply have it go to the residue of the trust.
Okay.
So like I told your classmate, I tell my clients in the real world, and again, for the benefit of the class, in estate planning, we deal with possibility and probability, and we have to deal with both. So it's possible James could die with his sons. It's not probable. The probability is I'm sorry, yeah, James will outlive his sons, and then his sons will die in natural orders. But we have to account for both possibility and probability. So
Gotcha.
in the real world, the probability is if James still owned this house when he passes, Kevin would survive him and Kevin will get the house. But if Kevin does not survive, then we want the value of the house to go into the residue. So you have some
Okay.
cleanup there. Yeah, this
Okay.
is
Yeah, number B is, I was totally confused.
right. Yeah, I can see that. I'm glad you called me or we're doing this. So I'm saying this for your benefit now. I know I'm going to post this to the course now.
Oh,
As long,
no.
and are you okay with that? If you're not okay with
Yeah,
that, I won't do it.
no, it's fine.
Or maybe because I went through one of your classmates on the phone, and um, this is really the crux of the assignment. So you got two things going here. Well, you actually have three things. He's disinheriting Jordan, okay? He's
Yep.
leaving the balance to three sons, but one son's a minor. So you're on the right path. So when you, I have to go to the course here for a second. So let's see.
And I do have him disinheriting. I do have that in here.
Okay, that's good. But what we need to do more importantly is we have to disinherit Jordan, but we have to disinherit him. I didn't read it in your trust yet, but I'm sure it's there. So you're explicitly disinheriting him, but we also have to disinherit him by implication. So let me show you
Oh,
this.
there was a, let me see.
See this sample? No, that's not it. Hold on for a second.
Yeah, I have that.
Let me let me open this because this will explain. I think this will help you. So this is the language I've simply provided as the base, and one thing you are doing properly is you're following the forms that I've provided, and that is part of the assignment. So here, the reason I've given the class this is this just shows where this person was just leaving two shares outright. So for our assignment, you would take this language here, and you
Okay.
would create three shares. One share would
Three
be,
shares.
yeah, so then one share would be outright to William, one share would be outright to Kevin, and then
Okay.
one share would be for the benefit of Robert, and that's where that Robert II trust language would be because Robert's a minor.
Okay.
So his share would be trapped in trust and then pursuant to the Robert trust rules, which I saw you, or trust language, which I saw you have in there. And then
Right.
what we do here, think about this for a second. If we do that, then you see this paragraph C, this lapse. So what we want to say is if for any reason any of our three shares will lapse, then you direct that the lapse share will be added to and distributed with the remaining shares. So for instance, if Kevin was to, wait a second, I got a note from, I'm getting a note from GoToMeeting here, but I'm going to keep going. So
Okay.
you're still hearing me fine, correct?
Yes.
Okay. So this article C, or this paragraph C, and I'm saying this again for your benefit and for the class, but what you have to do with this is you have to picture William getting a share outright, Kevin getting a share outright, and Robert's share being held in trust. The
Okay.
probability is Kirk will die, and that's exactly what will happen. However, if Kevin was to die predeceased James Kirk, then his share would lapse. And what we want to say is that there's a lapse share, then that share gets split among the remaining share or shares. The reason we do that, you could actually add a paragraph D, if you're going to be perfectly complete, and I think you should, and this came up with your classmate when I looked at hers over the telephone, but then paragraph D, we would say if all the above shares lapse. Now the odds of that are astronomical, but what if the three sons and the father were in the same car wreck, you know, that kind of thing? So you say
Right.
if all of the shares lapse, then you leave it to the Boy Scouts of America, the Red Cross, his church, whatever. And that would go in your list of assumptions. The reason for that is because if any share was to lapse, and this is, now I'm saying this for the class as well, if any share was to lapse and we don't know what to do with that share, Jordan might be able to take a part of that share as an heir of Kirk.
Okay.
An heir is a person who would inherit from the decedent had the decedent died intestate, which means no will. So Jordan technically is an heir of Kirk. He's just not going to be a legatee. A legatee is a person who takes under a will, or a beneficiary is a person who takes under a trust. So this is a really important part of the whole assignment, and it's what makes it so important in the real world, is to get those shares straight. So share 1, William, share 2, Kevin, share 3 vests in Robert, but then is trapped in a Robert trust. And then if any
Okay.
of those shares lapse, they get added to and distributed with the remaining shares. And then article or the next paragraph, however you're going to do it, if they all lapse, then, you know, pick a charity, you know, Red Cross or whatever, just so that there can never be a lapse back to Jordan. That's really important.
Okay.
Now let me close this language and go back to what you and I were looking at, which was the trust. So yeah, so you have some work to do there, but you have time, so
Gotcha.
that's good. I mean, that's really good. And then you'll have to, I'm just kind of scrolling this fast, just follow what I've done in the form language and see, then you have these you just got some cleanup to do here with the
Okay.
labs. And then right after this, right where I'm moving the cursor back and forth, right above sixth,
Uh-huh.
that would be where your ultimate lapse language, that if all these shares lapse, then I leave it to the Red Cross or Goodwill or Boy Scouts of America, you know,
Okay.
something like that. Then sixth is
Okay.
boilerplate, and you got this right. Yeah, that all looks good. You have this correct. James is a settlor. A settlor is a creator of a trust. A trustee is an administrator of a trust. So what James
So
is,
the trustee would be Bank of America.
no, no,
No?
because this is what we call, generically on the street, it's called a living trust,
Okay.
or sometimes we'll call this, legally, it's a self-declaration of trust. So you actually have this correct because the settlor is James. He's creating the trust. And he's also naming himself as trustee first.
Okay.
So it only becomes Bank of America if James either becomes incapacitated or passes on. So he
Okay.
signs 2 times. You have this right. He signs, I'm the creator of the trust, so I'll sign here. And I'm the trustee of the trust because I'm the administrator of the trust. Every trust has to have 4 elements. It has a settlor, a trustee, beneficiaries, and what we call corpus. So in our example, in our assignment, James is the settlor. He's the creator of the trust. James is
Okay.
also the trustee because he's the administrator of the trust.
Mhm.
If you think about it technically, he's the beneficiary first of the trust because it's his property, and we only go out to William, Kevin, and Robert upon James's passing. And then corpus means property. There has to be property in the trust. So that's why we have, I'm going to go forward here for a second. That's why we have
Okay.
Schedule A. But go back to the form that I provided. All we have to do is say, you don't have to put all his assets here. All you have to do is say $10 in cash. And what we're saying, the reason we do that is what we're saying is the day he signs this document in our office, one of those $10 bills in his wallet, he now holds as trustee so that this trust has corpus. But down the
Got
road, we're going to advise, and I'll get to that, but we're going to advise our client Kirk through Slate that he should be retitling these assets into the name of the trust. I think that's what you're doing here. So I think you want to
Gotcha.
take this stuff out. And then Professor Dean being nitpicky again, you'll fix this witness
Yep.
signature area and you'll get rid of some of this bold stuff here.
Yep.
All right, do you still have time?
Yeah.
All right, last thing, the list of assumptions, I think you're doing this right. A list of assumptions, this is a grading tool for me. So I saw a Diane Nichols in there, I saw some addresses. The list of assumptions is where you put that stuff. Like you had your signing date, I think was March 1. That's what goes here, so that when I'm grading it, I say, well, who's Diane Nichols? And then I look at the list of assumptions, oh, okay, this is the person who's going to be the witness, or where did March 1st come? Okay, you see, or where did Kevin's address, that kind of thing. So I think
Okay.
you're doing this fine. That's a grading tool for me. The last thing I want to do, and then I'll let you go, is I'm bringing up the assignment itself, which I probably should have done earlier. But so here's the assignment. I know you've been working with this. I just want to give some highlights to you and through you to the course. So if we go along here, I think you've done a good job at figuring out what he wants to do, especially with these, guardian of person, guardian of estate. He wants Bank of America to be trustee. So you've got a lot of this is very good. In the real world, if this was our client, we want to go back. Estate planning is driven by the assets. So often, too many lawyers and financial planners think that when we get these documents done, Kirk's estate plan is done. That's not true. So in estate planning, we really have 4 phases. Phase 1 is we meet the client, we hear his facts, we quote our fee, and he agrees. And then stage 2 is where you're at right now. We prepare draft documents, and when we got these good and ready in the real world, we'd send them to the client so that he could review the documents, make sure we didn't make a misspelling or anything like that. Stage 3, we come back with the client and we execute or sign the documents. And then stage 4, and this is where a lot of people drop the ball. Stage 4 is now that he has a trust, we have to retitle or reallocate assets to the trust. So that's why I've given you you meaning the class. So for instance, we know he has this residence and we know he wants this to go to his son, I believe it was Kevin, right?
Right.
Okay, so we know by operation of law right now, title is in Kirk's name because Sally, she died. So in the law office memo, we'd want to advise Slate that at the very least, a deed in trust needs to be prepared and recorded that would take the title from James in his own name to James as trustee of his trust.
Okay.
Forgetting all the other assets, the reason we would do that is if James was to die and we didn't do that, this house has a $250,000 fair market value, we'd have to open a probate. James is paying us to avoid a probate. So now knowing that and keeping that in mind, I forget what he wanted to do with I don't think he wants to do anything with the CREIT, right? So
it should be divided between William and Kevin per the, the balance of the estate.
No, because that's personal property, right? Let me see here. Yeah, I don't, check me on this, but
the remainder of his personal effects to be divided.
See, farmland's not personal effects. Farmland is real estate. See that? Boy, your classmates who listen to that are going to be really happy you did this. Anybody listening to this owes Edna a cup of coffee. So it's the same advice, wouldn't it be? This is a $500,000 farm. If he dies with it, he inherited in fee simple absolute, which means it's in his own name. Since we've created
so that should just go in trust.
That's right. You should advise. You don't have to do it for the assignment. This is the law office memo stuff.
Right.
You should advise Slate that a deed in trust transferring this property into the name of his trust has to be done just the same way as his residence. Now, if you're thinking about that and you're thinking correctly, then these shares of stock that are all owned in joint tenancy, we know Sally's gone. So by operation of law, he now owns this stock. Again, if he was to die or if he becomes incapacitated, nobody has any power to deal with this stock. So in the real world, we would advise that the transfer agent for these companies has to be contacted, and they have a package of forms that you would put together as a real world paralegal, and he would also sign those transferring, I'll just use the GE, transferring the stock from his name to his name as trustee of his trust. And what the transfer agent would want in the real world is they would also want Sally's death certificate, because on their records, she's a person. So then they would clear her off their records. So if you have that thinking in mind, and when I say you, I mean the class now, you got to go through these asset by asset and make sure that most of this ends up in his trust, because that's where his estate plan is. So again, this life insurance policy naming Sally and Jordan, well, Sally's gone, right? And
Jordan, so it'd go to Jordan, which he doesn't want.
And that's $500,000. That's malpractice. So what would we do? We would contact a life insurance company. We would advise Slate that we're going to have to contact the life insurance company, get a beneficiary designation change form, and get it completed and signed by Kirk. And those are usually available online. A place like Metropolitan Life would have those forms online.
Gotcha.
So the duplex here, however, on his death, James wants the duplex to be owned outright by Peter. Well, again, from an academic point of view, this is here to get you thinking about, wait a second, he owns this thing with James and Peter, so that means they own as tenants in common. So again, I think we'd advise Kirk, in the real world, we'd probably just have Peter and James deed this property from themselves as tenants in common to themselves as joint tenants with right of survivorship. That would be the cheap way out. If we wanted to do it more complete, if our clients wanted to really be perfect, we'd probably create a separate trust for this duplex.
Okay.
Again, I'm saying a lot of this for the value of the class more than you. Yeah, so that's it. So I think you got it. I mean, I think overall you're on your way, but you have some cleanup to do.
Okay.
All right. Do you have any questions?
Nope. I think you answered them all. I will clean all of this up and have it ready.
Okay. I'll be in my office on on Tuesday. If anybody has any questions, you can call me. I should be in my office on Tuesday between 12:30 and, oh no, I'll be in my office only from 12:30 to 1 because I have meetings at the college. But I can always answer questions via Moodle.
Okay.
And again, are you okay if I put this to the course, or you don't? If you don't want, I mean,
no, that's fine.
You sure? Because I think you've done a good job.
Thanks. Yeah, you can put it through. I don't mind.
All right. Then I'm going to sign off. Thank you very much.
Thank you. Okay. Bye-bye.
Bye-bye.